this Friday afternoon, February 7th. And we're going to have a walkthrough of this 66-page bill this Friday afternoon, H28, because Ken really asked me that to go into this bill very in depth. Or you can give us a quick overview of what your choice. So over to you. Thank you for, it's so nice to have you here. So
Good afternoon. I'm Jen Harvey from the Office of Legislative Counsel. I know some of you and not all of you. So nice to meet you for those I have not seen before. Yes, I'm usually doing healthcare stuff, but I also do some general drafting. And so this bill that we're looking at, H28, is an act relating to including an affirmation option in oath requirements in Titles 1 through 10 of the Vermont statutes annotated. So I'm going to stop there to say the idea behind this bill is actually a larger bill, which would be to replace, the sponsors wanted to replace all requirements for oath with requirements for oath or affirmation and make sure that that option was available everywhere in statute, that there is a reference to taking an oath or swearing to something. And so in looking at how to accomplish that, it appeared that there were many, many statutes to be amended. And so I propose that we take it in chunks and start with, I was looking for maybe what would get to approximately 100 sections. So 103 statutory sections in this one, and it takes us through Title 10. There are 33 titles. So that's what this is doing. Really, the whole purpose of this is to add the affirmation option expressly. It is implied because of some language in Title 1 that we'll look at in a minute, but it is not expressed as an option everywhere in statute that an oath or swearing is mentioned. While in some of these statutes, many of which have not been updated in a very long time, I found some outdated language to the extent that it was a very easy update. Non-substantive update, I did that. There are a few that I flagged for my colleagues that they may want to explore with the committees of jurisdiction. My favorite one on that is near the end, where there's a reference to tagly abused pyrometer or some instrument equally accurate. We're on bottom of page 60 for anybody who's interested. And I had to look up tagly abused pyrometer. It does not seem to have been used much in the last 100 years or so. So that may be ripe for an update, but that's not what we're doing here. We're not digging into the substance of all of these. I flagged that for somebody, but we are not touching it.
Thank you for that. Yeah.
Hydrometer?
Okay, that's good. I'm just curious because we are just updating adding affirmation to all these. So these are going to be statutes that are covering all different topics. So how does that work when we're only looking at it through one lens? Once it's out, like now, like what if somebody else, they want to edit this? We don't have any context to that. How does that work?
If somebody wanted to edit the underlying law,
Yeah.
this might not be the bill to do that in. I mean, they certainly could. They could propose to.
I couldn't imagine it'd be germane if the purpose of this is a simple change of sworn to active,
Right, potentially. I mean, I think that would be up to the clerk on the floor.
Okay.
But I think, similar to the technical corrections bill, where we're very clear that the intent is to make technical corrections where legislative counsel have identified errors or inconsistencies. People are generally good about not making substantive edit proposals to those.
Okay. That's just helpful as we look through this, like we're looking at it with one lens.
Yeah, yes, correct. Because, yes. And if it gets to the floor, I mean, I recall on a number of occasions that things have been found not germane because the only connection is that it has the same statutory language, which is not being changed, which is not the purpose of the bill. And anything beyond affirmation, it would extend beyond it. So I'm not concerned about that. Maybe I'm more concerned about this committee saying, oh, this looks interesting. That Tagliabue or whatever that one was.
All right, so just to look at the first few sections, and then I think you will get first and second sections, I think are important to look at. The third and so on will sort of give you a flavor for what's going on here. And then I'll show you a couple of sections at the end. So section 1 is amending, and I've given you some reader assistance headings. So Title 1, we're in Title 1 on page 1, line 13. And the first thing that's being amended is a provision in Title 1 VSA section 127, that is about oaths and affirmations. And under current law, it says oath shall include affirmation whereby law and affirmation may be substituted. In like cases, sworn shall include affirmed. The clearest language, it's a little also unclear where an affirmation may be substituted, where it may not be substituted. So this instead would say oath shall include affirmation in all cases and sworn shall include affirmed. This is sort of our belts and suspenders in addition to making the substantive or the changes in the bill itself. Section 2, there's language about sworn. So we're adding or affirmed. So similar to the first section, sworn or affirmed when applied to public officers required by the, and it's just a capitalization change, more formal with our Constitution, to take certain oaths or affirmations shall refer to those oaths or affirmations. When applied to other officers, it shall mean sworn or affirmed to the faithful discharge of duties at their offices before a person authorized to administer oaths and affirmations. That's really what it looks like throughout, is taking anywhere where it says oaths and adding and affirmation or affirmations, depending on the context. Yeah.
Well, I want you to define what an affirmation is versus sworn oath.
Oh, as I understand it, generally an oath is somebody, it can have religious overtones. I swear under God, or I swear, sometimes it's swear under penalty of perjury, but the affirmation has the same impact. Affirm is somebody sort of agreeing with, but not swearing. That term may feel exclusionary to some.
And usually it's affirmed by what's a consequence of
perjury.
Perjury.
I mean, I think the same language, yes, it's oaths are often under penalty of perjury as well. But I think in the first name sponsor might be a good one to talk about. Representative.
Yes,
Be a good one.
We'll have that one.
Talk about why she wanted this bill.
Yeah, no, great. Thank you.
Okay, so if you look at page 2, we get into title 2, again, it's adding and affirmation. In some cases, it's more appropriate to say oath or affirmation because the person is only taking one or the other at any given time. And so those are just describing what happens when the secretary or the new members of the Senate are sworn in or affirmed in. And then I've also updated some gendered language to be non-gendered language. So you'll see those kinds of changes throughout. And in some cases, there's just lack of clarity. And so tried to make things clearer. If there was a tendency in the older statutory drafting days to use phrases like above and below, where it was unclear what that reference was to, especially if you're not looking at the whole book. Now that we can pull up a single statute online, what does above mean? Or they kind of continue a thought from one section to another. When I was just reminding myself of earlier that was talking about a clerk that went with a certain office, someone in the Secretary of State's office, a legal assistant, and it started with such legal assistant, and who knows what such legal is. So I put in a legal assistant appointed pursuant to section 150, the previous section 155 of this chapter, and then one. So where there were opportunities, on page 6, where there were opportunities to bring greater clarity without changing any meaning, that is what I have done. So, and as I said, this goes through titles 1 through 10. If you look on page 65, there is an additional section that's in here that's very similar to and modeled on what we put typically in the technical corrections bill, which is in purpose, actually in this case, and interpretation. And it says the purpose of this act is to expressly include the option of an affirmation in each instance in which an oath or swearing is authorized or required throughout the first 10 titles, except in interstate compacts. So where there was an interstate compact where we have to enact exactly the same language as every other state that joins the compact, we didn't change anything. If it said oath, it'll still say oath. We don't want to mess with our compliance with compact provisions. Or as otherwise limited by law, if there were certain things that required language to be maintained. The act also makes other minor technical amendments to the language of the affected statutes for readability and consistency with VSA style. And then here's the language that's like what we put in tech corrections. It is the intent of the General Assembly that the technical amendments in this act shall not supersede substantive changes contained in other bills enacted by the General Assembly during the current biennium. Where possible, the technical amendments in this act shall be interpreted to be supplemental to other amendments to the same sections of statute, which is what we do anyway. But to the extent the provisions conflict, the substantive changes in other acts shall take precedence over the technical changes in this act. So if another committee is amending this same statute that appears in here, and they're doing something substantive and it still works to add the affirmation language that we were looking at in here, great. And if they have completely rewritten the statute, then what they say goes, assuming the legislature enacts it.
Any questions?
So none of
Try to
this,
make it more than 10 minutes.
none of this language here has anything to do with changing anything to do with whether it's a Vermont Constitution or the national Constitution, nothing like that, right?
We can't change anything in the Constitution.
Oh, I don't know, in this building, nothing surprises me.
They can in the Senate. They have to start it in the Senate. This is not a biennium for constitutional amendments. No, we are not touching the Constitution.
Start it next year.
You would know.
And fully comply with the Constitution, I'm sure, as well.
We are.
Any other questions?
So if anybody looks at anything and has questions about it, I'm happy to answer offline or come back.
I want to know if it was fun for you to do this.
A little bit of both. It started out fun. I will tell you, so this is a 66-page bill. I brought a 180-page bill to Senate Finance that they actually have already voted out, updating and reorganizing the health insurance statutes. That was another one that was fun right until it wasn't.
Thank you.
So,
Luckily, I like to draft, so it's good.
so would you have any suggestions of any witnesses that we might want to listen? I mean, just from your knowledge and having looked at, I have.
No, I mean, you might want to hear from the courts just to see if anything about this concerns them in any way. I think they would be the main, perhaps Secretary of State's office or somebody who is often in the position of putting things out that require oath or affirmation.
Thank you. Any other questions? I don't see. Thank you very much and have a great weekend.
Thank you, you too.
Thank you.
Thank you.
Find another reason for me to come back in.
Yeah, we'll look for it. Okay, and why don't we start with 41? Let's get Ben to continue his walkthrough interrupted for grammarian reasons. Grammatical?
Thank you for coming back today.
I'll always come back. Thank you for letting me come back. And I would like to say, the tech corrections bill is a sore subject for me because I am the drafter of that right now. So, you'll not be seeing that for some time though. Actually, you guys won't see it at all.
Well, we'll see it on the floor.
Before. You don't have to really do the dirty work.
Thank you. Hey, nice comma on line 9. Great. Is it highlighted?
Do you want me to share my screen for the comma?
No.
Okay. So good Friday afternoon, House Judiciary Committee. My name is Ben Novogrodsky from the Office of Legislative Counsel. Before the committee is now draft 4.1 of an act relating of a strike all amendment to an act relating to creating a felony penalty for abuse of a corpse, which if it ends up passing the House, will change, the name will change to an act relating to the abuse of the dead body of a person. You will see that on page 3, lines 4 and 5. Present in the last section, but I failed to highlight that. And then the difference between 3.1 and 4.1 is the change in location of the comma on page 1, line 9, from after knowingly to before knowingly.
Making it so much.
That's right. It's really a team effort in this committee and I appreciate it.
All right. Okay. So, and I think you didn't get through the other main changes from.
I did not. So the main changes from that were incorporated in 3.1 from the prior version was now really concerned the structure of the bill and then which types of conduct were felonized essentially. So I believe that I spoke to the removal of the terms hide and conceal from subsection A because it could arguably be handled in 18 VSA 5211, which if this bill were to pass would become a fine only rather than an possibility of imprisonment. And now subsection B has been restructured to read that no person shall intentionally bury, transport, hide, and conceal. So you're now seeing those terms rolled in with burn, mutilate, disfigure, dismember, or destroy the dead body of a person for the purpose of concealing a crime or avoiding apprehension, prosecution, or conviction of a crime. So you need to have the intent and ultimate objective of doing those, of committing that conduct to conceal a crime, which would not have been covered by those terms in 5211, because it has nothing to do with concealment or apprehension. It's really just a public health statute about obtaining burial permits that would permit transport or moving a body. So that's separate and apart from this. And so that conduct, if you had that extra intent, would now be covered by this portion of the law. And then finally, there is a subdivision 2, which discusses the sexual conduct portion. So no such person shall commit sexual conduct upon the dead body of a person. And then both subdivisions B1 and B2 are subject to the 15-year penalty rather than the 5-year penalty for violations of subsection A. So it would be imprisonment of not more than 15 years, fined not more than $10,000, or both for that, what I would call an aggravated penalty. And then finally, subsection D is the list of the definitions, which outside of the term dead body of a person remains unchanged from the prior version.
And the reason for the change back to dead body of a person was what?
The reason for the change to dead body of a person is because
Isn't it mainly because it's the language that's already used in
yes,
Title 18?
it's to be consistent with that. So to use that terminology to ensure that we're speaking of a person and it's already present in statute, so there's consistency there.
And I think there's also at least some case law that interprets that.
Yes, exactly.
Yeah, so
I can get into it if you'd like.
I don't think we need to open up this. Okay.
Was this already discussed and I missed it? Why wasn't this going to take effect on passage? Because we didn't have enough time?
July 1st, isn't it?
Yeah.
It's July 1st, 25.
Which, by the way, through the whole process, it's going to be pretty close to when this would get to the governor, because it's not going to be looked at until into March. And we always hear from state's attorneys that they need a little bit of time to update their charging documents and the like. So that's where
We talked about it. Then we talked about that.
we've heard about this. I don't know about on this.
It's not on this particular bill, but from our drafting conventions, July 1st is sort of the default, unless specified otherwise.
This is just so gory. It's just need it done. It's good. Thank you.
Yeah, and I think also given the relative infrequency of the behavior that this covers, presumably between the time the governor signs this and first, we won't have this as a permit. So,
Yeah, well, I hope it doesn't.
right.
It's totally understandable to me.
Say what?
It's totally understandable to me. I mean, all the reasons given, and we talked about it before, but with other bills. I don't think it's a big deal.
Okay, thank you.
Any other questions on this one? Everybody's good? In that case, I would.
I have a question.
Oh, yeah, go ahead. Yeah, go ahead.
then line 14 subsection B on the edited draft, or I guess the highlighted draft. And there's language removal. I'm curious on how does that change the intent of the bill? I guess.
Can you give me a specific?
Aggravated abuse of the dead body of a person, individual who violates subsection A of this section. Like, I'm just curious why,
Why remove the reader assistance heading?
yeah, well, no. Why was that removed? The aggravated abuse of the dead body of a person?
So the substance of it remains. It's just, and part of it is, after further consultation with my colleagues in the office, typically when we do an aggravated penalty, it's a standalone statute, not just a subsection to another statute. So rather than creating another one, it's just an enhanced penalty within, and that's common practice in other statutes. So if you look, for instance, at the criminal threatening statute, you'll see enhancements within that.
But in practice, it doesn't change the intent of the bill. Or the
No.
crimes.
No, the substance of it remains.
Good question. I'd missed that. Thanks, Eric. Other questions? Well, I'll take a motion to, I guess, first, approve the amendments, to the bill as introduced, that we've been going over. Is there a second? Several seconds, which we don't have to record at this point because this is from the amendment. All those in favor of the amendments that we've been making over the last week and a half or so, please say aye.
Aye.
All those opposed? All right, so the next, I take a motion and then we can have discussion as well, to approve draft number 4.1, which is H41 as amended.
So moved.
Is there a second?
Second.
Okay, Karen, second. So, any discussion? Open this up.
I just want to thank everybody. So. Not even my family. You know, I really don't, and I know Pam's on, and I really don't even know these people, but I just can't imagine going through what the family went through. And, I guess I had a goal in this is just to help people justice. Maybe calm their hearts and minds a little bit, but thank you to everybody.
Yeah.
And that's, can't wait to get on the freaking floor now.
Out there and- Yeah, thank you for bringing this. A good bill. It covers a lot. So, Angela.
Yeah, I want to say thank you to Tom and really express my gratitude and sympathy for our prime witness in the case. The ability to speak so clearly and powerfully about such a horrible, devastating loss. And to do it even, relatively close to that loss. I find that really, it takes an incredible amount of grace and strength to do that. And I just want to honor that grace and strength and honor the experience of the family, and of Roberta and her memory.
Yeah. Anyone else? Not seeing any, if clerk could read the
Arsenal,
Yes.
Dolan,
Yes.
good now,
Yes.
Roseland, yes, Harvey,
Yes.
Malloy,
Yes.
Oliver,
Yes.
Rachelson,
Yes.
Chrissy,
Yes.
Burdick,
Yes.
Malone,
yes.
7-0.
I understand that Tom wants to report this, so we know what we need to send to.
Yes and no, but.
We'll figure it out before the end of the day. So, get that to him. So, all right, thank you very much, everyone. I think that this is great work. It was. You bet. Thanks, Ben.
Problem.
Everybody take a deep breath.
It's important. Get it right.
And we will pass out the next bill. Yes.
Thank you.
Well, no, well, I hope so. I think there wasn't any controversy
no,
on
I
the
think
DUI bill either.
Just giving you a hard.
Mr. Chair, do you want me to share my screen on this one or just talk, like direct the committee to the specific portion that was changed from yesterday to today?
I think that, I think it's fine just to point out where the changes.
Okay.
I think we've gone over it, unless, the likely report of the bill, Ian, I think has, agreed that he would report it, unless you want to have Ben walk through the whole thing again.
I think for the sake of our committee, if I feel that is necessary, I will do it on my own. So,
Always available to help.
appreciate it.
Yes, so, all right, so, this is, draft number 3.1 of H44, available on our website for the viewing audience, and tell us about the hopefully final change.
Well, thank you, Mr. Chair. Again, Daniel Bogrotsky from the Office of Legislative Counsel. Before the committee is a strike all amendment to H44. The change from the last version concerns can be found on page 20. And now you'll see on lines 11 and 12 on page 20, it mirrors the language that you'd find in what is proposed to be new subdivision 3 on the same page. So that now, rather than an order of delinquency and proceedings concerning a child, that is struck. And it now reads a merits adjudication order issued pursuant to section 5229 of this title in proceedings concerning a child or youthful offender. And that is the same language in subdivision 3 and reflects the suggested change from yesterday.
Any questions on that change or on the bill generally? Other than it's a very confusing area of law, and I'm very glad that Ian's going to take this one on. So, with the backup of Tom Oliver, of course, who actually has applied this law in his career, or parts of it at least. All right, not seeing any questions, I will take a motion to approve the amendments that we have made over the last week to H44.
So moved.
For a second.
Second.
All right, all those in favor of the amendments that we have made to H44, please say aye.
Aye.
And I would take a motion to approve draft number 3.1, H44, strike all amendment as amended. Or is it strike all amendment? I shouldn't say strike all amendment as amended. That kind of sounded redundant.
That covers it all, you know.
Okay.
So moved.
All right, is there a second?
Second.
Further discussion? Oh, this is your bill too. Oh, okay, well, that's more important. That's more important. Well, I will just say that I'm happy about this work, and I'm happy that, I think this is the first bill that just, that the two of us have been the co-sponsors of, so. This
Is
great.
it?
Yeah, I think so.
Okay.
I think we have been on other
Okay.
bills, but
Okay.
not as the lead sponsor,
Right,
so,
now, we had a meeting with Mr. Weidman's
yeah.
this past summer about Wilson kind of crap.
Yeah. Read that this was a good thing to do, so. Anyway, not seeing any other discussion, or yeah, go ahead, yeah.
Not really about the bill, just about working together. And it is nice, that, what happened on the floor the last couple of days, it's pretty much partisan politics. And I mean, in here, it's partisan politics a lot of times, but it's just nice to come together on something.
Yeah, there's a lot that I think we can do and have done already, and we'll continue to do this session that I think we can get a lot of agreement on. I had enough controversy. I figured that this would make this all very smooth this time. All right, so any other discussion? Seeing none, if the clerk could call the roll.
Arsenal,
Yes.
Dolan,
Yes.
now,
Yes.
Forsythe, yes, Harvey,
Yes.
Malay,
Yes.
Oliver,
Yes.
Richardson,
Yes.
Christie,
Yes.
Burdick.
Yeah.
Lon,
Yes.
7-0.
And Ian, thank you very much. This will be exciting. You could be the first new of this class person to hit the
Yeah.
Oh, he's recording us and make us proud.
Yes, I will do my best to do.
So.
Lucky for you, you've already seen, we've already.
I've seen two.
Two
Yes.
old pros, you know.
And I'll have my caucus set up with 30 or 40 questions. Excellent questions.
Should we not talk about the hate scene?
Yeah. All three books.
Just, if I may, just for a moment, I just want to apologize, my attitude yesterday. I was a little prickly, I think would be a good way to put it. And
It's nice to know you're human.
I know, but my job is to remain, at your service no matter what. And, so I apologize for not being as professional as I should have been.
Not a problem. I like to have particularly strong emotions about commas and. If it was about policy, it's like, oh, come on, Ben. Just like, where does a comma go and do we change a few words? I think we can have open debates in here.
That said, it was a very elegant solution. The comma.
Yeah, very
But
nice.
Ben, thank you.
Yes.
Thank you.
Because
Thank you for
even
that.
though I don't think we were real concerned with it, it's good to know that you hold yourself to such a high standard.
Yeah.
It really is.
Yeah, thanks.
So, well, thank you. Appreciate that.
Absolutely is, absolutely is. So to stall, because we have one last thing I'm hoping folks will be able to hold out for, Michelle will be coming to just show us what's going on with H98, the adoption bill. I'm not looking for a vote, but we can take a look at it and I can have discussion, and if people feel they don't need more time, we can go ahead and vote that out. But not critical, obviously, that we do that. So just a heads up for the next couple weeks, and some just general issues for folks. These people haven't all heard this. So next week, we're gonna have a lot of testimony on Tuesday afternoon and Wednesday morning on the amendment to H2, the raise the age. Bringing in a whole bunch of people. That will probably not be the only testimony we take, but we'll get a bunch of input on what we have so far and probably go back a little bit to the drawing board, given that input. We'll have yet more testimony the following week. And then we're gonna start working and hearing from folks on the budget requests, that, both what's already in the governor's budget, request, and then I'm sure that some of the folks that you're gonna hear from are gonna want to have more than what is in the budget of the governors, and we'll hear from them. So we'll starting on Wednesday afternoon, hearing from the courts, the state's attorneys and defender general's office. I mean, I don't know, they may just be fine with whatever's in the governor recommend, but oftentimes there are some adjustments to what is in the governor's recommend. Thursday morning, we have a joint hearing, which should be very interesting, related to remote hearings, transports, and work through oversight with the Department of Correction, state's attorneys, defender general, and courts. And also, yeah,
Courts?
the courts as well, yeah, the courts. Not courts.
That's what I heard.
Yeah. So yeah, that we'll have on Thursday morning. And then we're going to continue the budget discussions with quite a bit on pre-charge diversion just generally in the Attorney General's office. Want to make sure everybody is brought back up to kind of date as far as what we did in Act 180, what additional resources might be needed, what's going on with the implementation, what we're expecting, and a request. Because I can tell you, I'm pretty sure that there's no money in the governor's recommend for that initiative. And at least for me, that's a top priority. And hopefully I can convince the rest of the committee that that's the case. Friday is kind of still open. At some point, we're going to get to some domestic violence bills. There's 2 requests in the Domestic Fiscality Review Commission that we have bills coming. And we have another bill that has to do with non-consensual tracking devices being tracked, and one victim being tracked in automobile or et cetera. So that's kind of in the near future. I can tell folks that at this point, we're not intending on doing any firearms bills. this session. I'm gonna take a pause from that. I probably will have a hearing, kind of an oversight hearing to how it's going as far as outreach with respect to ERPO laws, the extreme risk protection order laws, and the use orders involving firearms, just to kind of get an update on what's going on with that. Then, we have only 4 weeks after this week before crossover. And love to hear if there are burning issues that people want us to take up. So I can kind of consider that for down the road. I do have a bail revocation bill that we'll take up. I think I'm going to try to largely mirror the language in the governor's budget, not budget, omnibus bill on public safety. We may have some additional language that I'm working on as well. I frankly will tell you that I don't know if I'd say I'm skeptical. I'm going to be open-minded, but I know I pushed this in the last 2 years. I pushed it, and we keep on running into the Constitution and certain case law, but we'll dig in again and see if there's something more we can do to tighten up the bail revocation law. Trying to remember if there's any other big other things. We've probably got some victim stuff coming down the road, but we're running out of time. So any input on that? Yes.
In our very moving testimony today, I mean, especially given our moving testimony today, I just hope we keep that placeholder for doing the victim bill, because I don't want it to be, we didn't have time to do it.
Yeah, and we need to get what those bills are
Yes, we did.
out soon, so. Anything else? I think we are going to probably see a ceiling bill after crossover. They keep on working on it downstairs. And they did, your bill is now on the floor, your companion bill for the after hours. So that's.
The after hours of weekend sexual assault civil order. Be able to get one.
Are there any other things that people know that are coming down the pipe that want to make sure it's on my radar for figuring out on the agenda? Ian, do you have?
Yeah, if that one that, the no trespass one.
Don't remind me.
It's,
yeah, right.
That comes, I haven't gotten yet, but if it comes in time,
So who's the draft of it?
I send it to Michelle.
So when I talk to her, when we have a meeting every Thursday with all the state council and the Senate. And I can urge her to get, move that to the top. Can you explain that really quickly? Because that one seems it's going to be non-controversial for us. I think there's a lot of support.
Yeah, and it's coming, I think Martin was what he said. It's coming from Brattleboro, so that means that it's coming from Brattleboro, and it's kind of a landlord rights thing. It's bipartisan. Basically, right now there's a gap in the law around no trespassing individuals from buildings that involve like a lot of tenants. And if you have a individual who's a non-tenant who's creating havoc, breaking laws, things like that, right now to no trespass them from a building.
Guest of another.
What's that?
Would they be like a guest from another apartment? Is that?
Could be a guest. It also could be someone who's like just going into the common areas.
Yeah.
Right now you have to get a signature from every single person who lives in the
Oh my God.
So in Brattleboro, where that really is impacting us is we have some, like the Wyndham Windsor Housing Trust who came to me about this with the state's attorney's office. They basically have individuals who are really causing harm for the people who live in these buildings, and they can't no trespass them, and they have to wait till there's more law enforcement involved. And what's happening is it's really hurting families. So who live there. So that's kind of the hope is to try to close that circle a little bit so that there's a more expedited route to be able to no trespass a non-tenant who lives in, who's in that area, who's broken a law or who's been alleged to have broken a law or broken a policy of the space. And that they don't have to get all of the signatures of everybody. So
Who would they have to get?
What's that?
How many would they have to get, or maybe the superintendent of the building or the owner?
Well, it's the owner that and I apologize, I wasn't clear. It's the owner who has to get a no trespass order. So right now, the owner of the building has to get signatures from every tenant to no trespass someone.
So you would go to just him with.
Just the owner.
Oh.
Yeah, no,
Or maybe the manager
like a
the owner
property
is-
manager. Yeah.
across the country.
Yeah, I haven't seen the language back yet. The Virginia, there's a law in the book that sort of works on this somewhat. There's some case law that makes it complicated, but the idea is just that, yeah, you're the owner of the property would be able to take a step to no trespass somebody in advance of having to get all the signatures, or basically wait till there's like a criminal proceeding that, yeah, it couldn't get them to get a no trespass.
Cool.
You said a lot of tenants. What's a lot of tenants to you?
So like Wyndham Windsor Housing Trust has a property that has like 80 tenants.
So are you gonna put like it has to have so many tenants, or is it gonna be?
I assume 2 or more.
Yeah,
Is that what you're assuming?
I'm assuming that we would try to get it so that you don't need all of the tenants. So I think having someone who lives there sign makes sense. But it's trying to, I think it's too far in one direction. It needs to be more.
Because we have that problem in Burlington, right? If that-
Oh, and that's the other thing. I had a call with someone from Wyndham Windsor Housing Trust, and she was pretty clear that this is an issue across the state. And that
It
there are
is.
people who would be willing to testify about it from a lot of different areas that,
But it sounds like you're not, I think part of what what you were
Yeah,
asking
I
is there a minimum number of tenants for the law to apply? And I think you're saying no.
No,
right now,
No.
no, in the build.
As proposed.
as proposed, it would be none. You wouldn't need any tenants to sign because we're trying to no trespass.
But no tenants, no limit on it, or like not a threshold for a number of people who live there either. Like a building of this size.
I understand. I misunderstood the question. That hasn't come up yet. I don't know. Maybe that actually is something to consider because with a smaller property, maybe it's not unreasonable to ask for everyone to have a signature from everyone. But I guess the question would be, where do you draw that line? What they're finding right now is for the low income housing where this is an issue, there's also a lot of movement of people. And so a no trespass would basically no longer be in effect if you have new people living there who no longer had signed on. So it's like just doesn't work the way that it should be right now.
It's so interesting that it was crafted that way to begin with.
I think
Around the retaliation. Yeah, that's what I was gonna say. If it's none, then if you have one person that lives there, and they're the one you need the signature from, but they're afraid to ostracize that person off the property,
yeah.
fear of retaliation.
So maybe
Because
it's
we've seen that in cases.
Yeah.
yeah.
That have gone before the HRC for housing.
Yeah. So it implicates some pretty interesting landlord tenant law. And I think Vermont has really good landlord tenant law in a lot of ways, but in this instance, I think that there should be a correction. Is that helpful?
Better one of each.
Yeah, H98, Michelle should be on her way.
You're asking for,
Substantiation.
But,
The substantiation.
oh, okay, that hasn't come through when you.
Ben's finishing it up now. It'll be a committee thing. And so,
Oh, okay, is it gonna start there or will it start here?
well, I'll let you look it up. Can't copy it out from my phone.
oh, really? I'm just gonna put in a plug for the possession bill.
Say it again? Oh, the writ of possession, we had that momentarily on writ of possession. Which one's that one? No,
I was pointing to it.
21.
Page 21.
I gave folks heads up that they might be contacted for testimony, so.
Call Dan?
Can I,
Hi.
can I take
His name.
this moment
Oh,
to?
okay.
I've lost everyone. But those, the two domestic violence fatality review commission bills, I asked if anyone wanted to sign on, and I know I didn't want to like send everyone the bills, so I didn't know if it'd be easier to just quickly tell everyone what they're about, and you don't have to tell me on camera if you wanna.
Yeah.
Sponsor. But the two requests were, one is a bill that establishes.
Wait, everybody, just hold up for just 1 second. So Angela is just gonna explain two bills real quick. We'll move over.
So one, the first is a bill to establish a temporary working group to develop a uniform process to ensure compliance with court orders to surrender firearms and report its recommendations to the General Assembly. The first one, and these are both just straight up recommendations from the Domestic Violence Fatality Review Commission. So the other one is, wanted to read it exactly, but, yes, authorize a court to order a defendant to complete a domestic violence accountability program approved by the Council on Domestic Violence as a condition of final relief from abuse order. One is a working group, a temporary working group to see how relinquishment of firearms is going. And the other one is to say you can order in a final RFA, order someone to undergo domestic violence.
So email or text you by when? End of the day, by Monday?
2:30. Ideally, so I
Next
can
half
tell.
hour. Okay. Text or email.
So that I can check it off my mental list.
I know.
Okay.
And if you need more time to think about it, I can be flexible.
Like 2:45.
Okay,
Tuesday.
over then to Michelle and H98. Thank you for being here.
Good afternoon. So for the record, Michelle Childs, Office of Legislative Counsel, and everyone should have a copy of your committee strike all amendment to H98. It's draft 1.3. So I'm just going to go through the highlighted sections if that's okay with you.
Yes.
So section 1 in the definition section in subsection A, you'll see I added the definition of donor. This is the definition of donor that you have in Title 15C. So it's just bringing it over so that makes it a little easier for folks to understand when we're working in the adoption title, what we're talking about when we talk about a donor. So that's the first change. Then the next change, I think I didn't highlight this, but on subsection C, on subdivision 1, says the petition for adoption signed by all, and I put parents before it. It said parties, and I think maybe Judge Zone had raised an issue about C1.
C1 was Brian,
Yeah.
it's on page 2.
Oh,
Right.
thank you, Nate.
The requests.
Then on subdivision C3, there's a requirement for the declaration signed by the parents explaining the circumstances of the child's birth through assisted reproduction, attesting to their consent to assisted reproduction. And then this was the part, there were a couple of different places that Judge Zone raised the issue about using the language around that, that parentage is not contested by another party. That is the language that you use in Title 15C, but not a problem to change it. And so now it would say, and stating that there are no other persons for the claim to parentage of the child under that title, under Title 15C. Subsection E, don't need that reference because now that you have the definition of donor in subsection A, you don't need to have that reference there. And I think it just adds a little confusion. Subdivision F1, Judge Zone felt a little better having just explicitly clarification there that when it says that you don't have to have that you're not to have an in-person hearing, that they could still do like a Zoom hearing or something like that. So adding some language there. Page 4. And this was the issue where before it said that the court had to act within 30 days on the petition, and we now have on line 3, there's to act promptly after the filing of a complete petition. And then subdivision G2B. And this is on when the court is making the determination and they're looking at specifically with regard to non-marital parents, that no other person has a claim to parentage. And this kind of ties back into that other language because these were the two places where it said that there were no competing claims of parentage. And so they will be using that standard. Subsection I on line 19 says person, it said party before, so I just eliminated references to party. And then I changed in section 2 on page 5. Effective date, I had put it as originally September 1st of this year. Changed that to July 1st. So all of yesterday's witnesses have seen the language and approve of it and signed off and support the language.
Are there questions? Go ahead, Barbara.
I had a question, but given that everybody signed off, maybe it isn't really a question. I wondered about the page 3, although the court may require a remote hearing. One thing that I started thinking about is like, if there is some kind of issue with a remote hearing, does that and the judge wants to have a hearing, would the judge be able to just ask for an in-person hearing, given that?
They could now, yes, they could on there because it says unless otherwise ordered by the court for good cause shown. So if there's some kind of reason why they feel as though, one, they have to keep the hearing, and two, remote hearing isn't going to work, the court has a discretion.
Okay.
So I assume because since there's a lot of changes that we're not ready to vote this today unless people tell me, oh, let's just vote it. But I assume.
I can have a clean copy for you in just a minute if you do want to vote it.
Okay, see where we are.
That's okay.
We are all ready to vote this out. Yeah.
Don't know why we're rushing on this, but
No, I'm not. If we're not ready, we're not ready. We'll
Like to read it.
Okay, yeah, that's fine. We'll plan on doing this first thing on Tuesday before we get back into H2. I'll put that on the calendar for a half hour or something to maybe that. Well, I put it on for shorter time. If we end up taking a little time, that's fine. But give people a chance to look at it. And I guess the other question I would just ask, is there anything that anybody kind of still needs or wants on this bill? Not asking folks where they are as far as what they're gonna vote on, but just if there's. Yes, go ahead.
So with the change to line 15 on page 3, Judge Zone A or a representative of the Judiciary, when you ran it by them, did they feel like this satisfied sort of the concern around like being able to like read the dynamic? Yeah, okay.
All right, well, good. So we are at